economic downturn directly as a result of the pandemic. Normally, sir, in the ordinary course of things, and the honorable member, leader of the opposition on the other side, he spoke to this last time, where the employer could not pay the severance that was due. The employee would then have to apply to the severance payment tribunal, and regrettably, and some would say almost in tragedy, and sometimes, is that their matters still before the tribunal, and they have been there for decades, or indeed long periods of time. And he spoke about this. The government felt then and still feel that a truncated process was required as a matter of fairness to those employees who would now have to wait 22 weeks at that time before they could claim severance. And we had a fairly heated debate in this honorable chamber, and in the end, the matter was resolved almost unanimously, almost. In that amendment to the Act, we therefore stipulated that the existing tribunal procedures were not applied to those cases. In other words, that people having to wait 22 weeks before claiming and then having to go through that process would not be really what we wanted. And then the Act spoke to the fact that the minister would instead make an order which would set out a truncated process for the processing and the hearing of the claims. Unfortunately, Mr. President, the relevant order that was spoken about, the relevant order putting the new procedures in place, has not yet been made. The amendment that was made last year is now spent. We therefore need to extend the time within which the minister can make that order, sir. This bill doesn't amend the Severance Act payment at all, but rather it is just, as I said, a short bill and a simple bill, which in essence revives the power of the minister to make that required order. And this time it sets a time for that to be done, for the making of the order, and this time limit is May the 31st, 2021. This is all that we intend to do with this bill. The order, I have been informed, is being worked on assiduously and will most definitely be made before May the 31st. The bill, Mr. President, also validates past actions of the NIS in plain claims where there is no dispute as to the entitlement or as to the amount of severance payments due to the employee. In such cases, for quite some time, and even before the COVID pandemic, the NS board paid severance due where the employer could not pay it, and thereby obviate the need for the employer to go to the tribunal and add to the already huge backlog. So they were indeed trying to assist those displaced employees. It is contended that this procedure that was adopted by the board may be challenged in the future. Indeed, there may be attorneys here sitting opposite me who might want to do so. Mr. President, I said attorneys. Mr. President, rather than leaving those recipients of such payments at risk of having the payments challenged for whatever reason, and the potential liability to be repaired, as could happen if an employer who wants to get out of refunding the INS board decided to challenge the payment, it is now considered appropriate to validate any payments so made. Mr. President, the immediate impact of this amendment will be to have the outstanding claims done with dispatch, and among the beneficiaries would be scores of hospitality workers that we see demonstrating from time to time, and indeed the Barbados employed LIAT personnel who we've heard recently of their plight. Especially, I know that the honorable leader on the other side will be aware of this, because I saw in the press that a cadre of former Leah employees had gone to visit the headquarters of the party, wherever it exists, to have discussions. So I know that he will certainly be gratified by this amendment and be in full support of it, recognizing the importance in easing the hardships of these poor Barbadians who have worked hard and assiduously and now are having difficulty in getting access to this severance. And we, Mr. President, are simply trying to assist in that process. With these few words, Mr. President, I beg that this bill be now read a second time. Thank you.
Thank you, Senator Walker. Senator Franklin.
Thank you very much, Mr. President. I shan't be long. I recognize that Senator Walcott knows that they made a mistake, a very bad mistake, and I am not one for rubbing salt in wounds. But even though I'm not one for doing it, there are times when you might have to. And I want to start by saying, commenting on some things that Senator Walcott said. He said that the NIS paid claims without going to the tribunal, which is a horrible injustice. That's more like misappropriation of funds, because only the tribunal can authorize the National Insurance Director to pay money from the board, even if it is not contentious. If it is a case where the employer says, I am not contesting the severance application, you still have to come before the tribunal, and the tribunal have to make an order, or the assent cannot legally leave the severance payments fund by anybody. But that happens, sir, when you have senior public officers in acting positions for too long. Because if the Director of National Insurance was an appointed officer to that post, they might have a little strength to tell the minister, but minister, no, you can't do that. But when you're acting and you're holding on for 2 years, 3 years, and didn't get the job yet, despite the fact that the act says that you should be doing it for more than a year. So minister said, pay them out the severance fund. You go and pay the severance fund, even though you had no lawful authority to do so. That is why even though this is not, I'll take a little bit of license, sir. Even though this is not a debate about the Public Service Act, it says to us that if the Public Service Act was implemented properly and allow officers to be appointed to these positions and don't have people in temporary positions at very senior levels, then we will have better administration. But people are saying, if I tell the ministers no, I might not act no more. So you continue to act, and you continue to take money without the lawful authority from the National Insurance Fund, not National Insurance Fund, sorry, Severance Payments Fund, without any authority in law, or even in common sense. But, so I just wanted to clarify that point with Senator Walker. They had no right taking it out. What bill? And he says that it does not amend the Severance Payments Act. Sir, Senator Walker is not reading the same piece of legislation that I am reading, because it is saying here at Clause 4, Correction of Error in Severance Payment Amendment Act 2020, Act 2020 number 15. Clause 4. So this is what you are actually doing. You are amending a piece of legislation that is no longer on the books in Barbados because the Severance Payment Amendment Act 2020 had a very short life. It's from the 1st of June until the 31st of July, and then thereafter it is spent. You know, I understand that the Minister of Labor is a minister of religion, you know, and he would be familiar with the story of when Lazarus died about 5 or so days. You know, the master came and he said, Lazarus, come forth. But this thing they died for nearly a year. And they want to revive it. They want to be better than Jesus now? No. No, I'm serious. The thing dead. You cannot revive the dead. After 5 days, Jesus fixed up Lazarus. But no, this thing died the 31st of July, August, September, October, November, December, January, February, March, April, May. That's 10 months. This is skeletal now. So you can't revive it to fix it. So if Samuel Walker would graciously say that they would withdraw this thing and let me go home, I can sit down. Because there is no way.
Mr. President, I raise a point of order.
Yes.
I really
Senator.
didn't want to interrupt the member since he's reflecting on what he learned in Sunday school. But the member is misleading the House. The minister, Mr. Chairman, Mr. President, under the provisions of paragraph 2G of the Severance Fund, Delegation of Functions Order 1973, delegated to the National Insurance Board the determination of applications by employees for payment of severance. So I think that the member is misleading the House to suggest that the minister and by extension the board does not have the authority to pay severance payments to employees. He's misleading the House, Mr. President.
Thank you very much, Senator Horton. Senator.
Sir, I don't want to tell her that she's wrong and
you-
waste time on it because I might run out.
That's
But
all.
she obviously doesn't know what she's talking about. The minister is the person responsible for the severance fund. Severance money is not national insurance money. But we had a structure in national insurance. So rather than create a new severance department and do that, the minister delegated the power to the board to administer, not to pay out, because the board does not give a judicial decision. And severance and matters from the tribunal are actually quasi-judicial decisions. These people go before the governor and take an oath to administer, and ask one of the chairman here if they don't have to go and take an oath so that they can issue decisions, because you are ordering people to pay money. So it is not the tribunal, it is not the severance payment, not the tribunal, the National Insurance Board. It's the Severance Payment Tribunal that's the only authority that has power to order that money out of the fund. Yes, the National Insurance people administer it, because the chairman of the tribunal walk with the Severance Payment Fund in their pocket. So they actually do the administrative work while the Severance Payment Tribunals do the judicial work. Because look, sir, if an order is made against you to pay money, you don't have it or you don't want to pay, the National Insurance Board will pay that money, and then they are empowered not to go after you as the person who has a judgment against you. That is why you see, I don't understand why this government is making this kind of mistakes. They don't know what they're doing. Because I've seen in the newspaper where the minister himself is saying that they are going to go on, that the National Insurance will pay, but the Minister of Labor, that and they will go after the employers. You could only go after the employer if there is a decision against him. There's none. Because according to what Senator Walker just said, and according to what we said all last year, you remove the tribunal from hearing these matters. So there is no longer a judicial body to give you a judgment. So having not gotten the judgment, what are you going to enforce? Right? So I don't mind people interrupting me, but interrupt me when you're right. You know? So as a result of all of these things, you know, I believe, right, in this society where people in high office are expected to do the honorable thing when they mess up, the Minister of Labor, the Attorney General, and the Minister responsible for servants should resign or be fired. And the General Secretary of Barbados Workers Union should be wearing sackcloth and ashes. You know, because all of them have done serious harm to the people of this country, and some of them have actually misled the workers into believing with government propaganda. You know? All the things that are happening now, with the people trying to get severance, were reasonably foreseeable. As a matter of fact, I, in my limited way, pointed out a few. And then one of the only severance payment experts in the entire Parliament got up in the Senate and told them that they were also wrong. Don't listen to me because I'm in the opposition. You don't want to hear me because I might be misleading you. But listen to Senator Tate for Hannah Axe to grind. Senator Monique Tate stood up after me in the Senate and pointed out where you were going wrong. You think we would listen to her? She's the expert in severance thing. She's one of the, as a matter of fact, she's the only one in the entire Parliament. I'm not an expert, I know a few little things, but she's the expert on it. You don't listen to the experts? She chairs one of them. There are four. She chairs one. I don't care who selected her. She's done it well, and she was doing it before you came into office. I have appeared before on a few occasions. And that's why I can commend her, because she handles it, she knows what she's doing. And she was telling you what to do, but you ignored her. Yeah, you ignored her. When I say you, I mean your government. You ignored her to your detriment. I know you are here embarrassingly coming before us like snow, with tail between your legs when she messed in the house. Because you did something wrong.
Senator Franklin, did you see the chair's permission before calling the name of that member of your family?
I apologize for that, sir.
No.
I apologize for that, sir.
Press on, sir.
You know? And coming here now with this, I would be embarrassed. I would say, please forgive me, for I've sinned. That's what you should do. And then then I would say that I'm not going to say anything more, because they realize that they were wrong. And they're trying to undo the harm that they have done to workers. But I can tell you something. It isn't easy to undo the harm that you have done to workers. You took the Severance Payment Act, made some amendments so that people will not be able to claim severance, not after 13 weeks anymore, but after 22 weeks. And then after these 22 weeks, you came up with something called a BEST program. It's the worst program possible. And that there was also in an effort to stop the workers from claiming their severance. You tell them, oh, you will remain in jobs, you know, and you will get 80% of your wages. First of all, government can't tell an employer to get about 80% of wages, because if you give me less than my contract sum, you just dismiss me. But people don't know, so people take the 80%. But worse yet, they actually took the money and did whatever they had to do instead of paying the workers, because some workers get 2 and 3 days. So you are now getting 80% of 3 days when you were getting 100% for 5 and 6 days. Moment you're not getting service charge, because there are no people in the hotels. So people are going home. One woman told me that after the deduction, she get $13. This is what you did to workers. So people ended up, some losing relationships because they were not able to finance them. Relationships. All of this is a consequence of what you've done. At least, if they had gotten the severance pay, you'd allowed the act to remain as it was, they wouldn't have lost them so soon. Precisely. You know? People have to find, no, not me, I don't know about that. But you came up with this idea all in an effort to take some pressure off the people who had money. I well recall one hotel property had enough money to pay the severance pay. And they were paying it in 2 tranches. But when they discovered that the legislation was so flawed that they didn't have to pay, they didn't bother to pay the workers, the next set. Sir, I must, well, since Senator Rogers confessed to them, I'm going to confess now too. The workers came to see me. I said to them, you are not members of my union, so I cannot call this, because I wanted a demonstration and go on strike. And I said, I cannot lead you because I will be breaking the law. I can only represent my members. But if I were you, if I were in your position, now I'm not telling you to do this, but if I were in your position, I would call the Nation, Barbados, the CBC, and everybody else and tell them I demonstrate outside the hotel. And when the police come, leave the place, because the police can tell you move and keep moving. If you don't move, they lock here. But they got to warn you first. So you're going, I would do that. Not telling you to do it. Boy, and some of them might do it. And the hotel man paid the check. They had them. But then, and you see, because what happened is, it went viral. All on the YouTube and every kind of thing, and the people outside of Barbados, and even the managers and the owners from expatriate owners, saw what was happening with their business in Barbados, and call back and tell them, pay the people the money, pay the people the money. They had it. But the local managers, they said, man, look, we ain't going to pay this thing, because they get advice from good lawyers. And they refused to pay because the amendments to last year's act did not force anybody to pay, because it says the tribunal, as a matter of fact, it said Section 30 of the Principal Act does not apply to cases, to claims made under this amendment. I think that's as close as I can remember the words. But it was something like that. So but Section 38 is the section that gives the tribunal the power to hear and determine claims. So when they discovered that that was the case, that nobody can force them to pay, they did it. The legislation also said, the amendment last year, that the minister may make an order to prescribe the procedure for investigating claims and that kind of stuff. The minister was supposed to make an order. That order would have to have replaced the tribunal, because you get rid of the tribunal. So there's nothing left now. So you had 4 weeks in which to make the claim to the employer after you qualify for the severance pay. Thereafter, if you didn't receive the money from the employer, then you had to go to the tribunal. But there was no tribunal. So there's no tribunal to order you. So the employers who found out, some of them paid, but the ones who found out that I don't have to pay didn't. So you're trying to fix this now. So you are trying now to breathe life back into this skeleton by giving the minister the right to make this claim, this order by the 31st of this month. But make an order for what? Or because he has to make it under some law. The Severance Payments Act. And particularly the Severance Payments Amendment Act 2020. But that is dead. So he's going to make a claim. He's going to make these orders to implement the Severance Payment Act 2020. That did. So you see, what the government has done, they rush to help the employers out of a hole without thinking through what they were doing. And as a result, they made it worse for themselves. They made it worse for everybody because people are suffering, you know. And you hear that people cares. I prefer to spend my money than to go there begging somebody for theirs or begging for a care package. One man came to my office and he told me he worked at a hotel and his wife worked in a restaurant and both of them got sent home. And, you know, as luck will have it, you're home all the time, wife pretty. he got a little bit now. I know a job. I know severance pay. But that happens. You know, it's the natural order of things. Mr. President, I have grave difficulty with what the government is trying to do in terms of now creating a liability for employers that they don't have today. And you're going to create this liability by the 31st of this month and then backdate it to sometime last year. But that sounds unconstitutional. Because I didn't have a liability to pay anybody anything today, up to today. Now you are going to create a liability for me, cause me to spend money. Mind you, the money is money that if the government had not messed up legislation, that would have to pay anyhow. But you give them a break. When I said you would mean the Parliament, you give them a break. Tell them, they didn't tell them in those words, but I remember saying in the debate that this seems like a way to let the employers off the hook. And the employers recognized that they were off the hook and refused to pay, even though some of them could have paid. But tell me something. You got some money there, and you can hold it for a rainy day, and somebody says, well, you don't have to pay. And what are you going to do? You're going to pay though? So these people are not like us in here who cares. I'm talking about me, it cares. These are business people who crunch the numbers. So you have to make sure that you have laws in place for them. Because I suspect some of them are going to fight any move for you to create a liability in the past and make them pay. Because if the minister make an order now, he can make an order from today. He can't make an order from last year. And especially an order that deprives a person of their money. Money is property. You can't deprive people of property. That's constitutional. Without due process of law, where's the case against them? And while there's a case against that, click. I understand. No cases. The tribunal, no tribunal, and they pay out the money. I want to ask, under whose authority? Where I want to find out, because I don't know. I'm honestly now seeking information and seeking assistance. Who gave anybody the right to pay out any money? I'm not going to tell somebody and to tell the employer or the former employer that he has to pay back money that you illegally spent or that you illegally take from the Severance Payments Fund. You know, the people that said two wrongs don't make it right. So it was wrong for you to do it, and now you're going to be wrong even for you to go back at these people. And I said back then that this will become a liability for the government because the government has taken away that from the employer and didn't put anything in place. But I want to touch on a few things, other things. Some employers pay severance, but they pay pittance in terms of what they should have paid. Severance payment is calculated on the last 104 weeks' wages. 2 years. You total the amount of money you get for the last 2 years, and then you divide it by 104, and that gives you your weekly average. And then you pay 2.5 weeks for the first 10 years, 3 weeks for the next 10, and 3.5 for the next 10, and the next 13. What some employers have done, because people were laid off last year a lot, they put in those slots 0.00. Enough, 22 or 21, 0.00. And then when they total it up and divide by 104, people got pittance. But that is not what the regulations say. I brought the regulations with me today. If you are on sick leave or on layoff for any period during that last 104 weeks, what the employer must do, instead of putting 0.0 in that space, the regulations provide that the employer will find the average of the last 4 weeks that you work. The last 4 weeks, they find the average, and that average goes in those slots. So even though you made no money, you were home on layoff, if your average was $100 a week, they put $100 a week in those spots. So you will still have a decent severance pay, but nobody is doing it, not even National Insurance. Check the regulations. It isn't in the regulations, it's in the schedule to the Severance Payments Act. Yes, it says here, the second schedule to the Severance Payments Act, paragraph 5 says, where in any week the employee is for the whole or part of the week A, incapable of work because of sickness or injury, absent from work because of temporary cessation of work, or absent from work in circumstances that such by arrangement or custom he is regarded as continuing employment of his employer for all or any purposes that week shall, notwithstanding that it does not fall within paragraph 3, we're going to read paragraph 3 for you, count as the period of employment. So those weeks inside there, they don't count as employment. They don't count as, so you just not off and not getting the money. But what we have been doing is shortchanging the people, and everybody is doing it and happy, and the employers are now doing even dirtier. They are, even though they've put those 0.0s inside there when they shouldn't, they are giving people 20 hours, 21 hours a week. So now, for that, and they are giving, and because you can't go now and claim your severance pay because of what mess the government did to you, you go back to work, and you're working for pittance. You're working for $120 a week. So even after the third, so if you claim severance now, it's going back to 13 weeks. When those 13 weeks, you'll be working for $100, $200. People who are working for $1,000 some dollars a week, when they come, not only working for $100. So this legislation that we passed in 2020 did serious damage to the people who voted for you. But you said, give me the vote and watch me, and I hope they're watching. Because there are a lot of people out there that you're unfair, you know. You did some serious harm to these people Some of them lose apartments that they were renting. They had to go back home with their mother. They go back and share barrel with the little sister and the little children and the other children. All kind of things happening because government did not look out for the people who were most vulnerable. The most vulnerable people in this thing were not the employers, but you did everything possible. You tried to revamp the best program when the hotel people threatened to lay off more people if you don't release the conditions. Yeah, they had a meeting. I wasn't there, but I had a present. I had a present. So now you hear them coming back and saying, oh, they're going to fix the best program. No, they're going again to help the employer against the workers. Now let me tell you something. In the United States, they give them stimulus money. The government gives stimulus money, but the government in the United States gives stimulus money to the employees. This government gives the stimulus money to the employer and let the employers administer it. So you know what can happen? The employers keep it for themselves and report a lot of nonsense to the government that ain't really true. And holding up on the pocket full of cash. And workers suffering. And then your solution, give them a care package. Only this morning, sir, I took up my newspaper. Well, it's not newspaper, no, it's Barbados Today. And I saw the chairman of the what do you call it? The National Insurance saying payment secured for ex-hotel workers by NIS. And this person is a lawyer. And everything that he said in this article is contrary to law. It's article by one gentleman called Kareem Smith, and it starts, the employees of Aqua Beach Hotel and Spa and the Hilton Barbados Resort have been given the assurance that their outstanding severance is currently being processed by the National Insurance Scheme. How can you process these things by the National Insurance Scheme and we are trying to pass the act to process them? This act, No, he quote the chairman. The chairman is saying that they are doing this thing all like now. You know? And the chairman is saying that we are doing these things all like now. But you don't have any authority to do so. Right? Ask for forgiveness. You know, ask for forgiveness. Tell the people of this country that we messed up. We did wrong. Come clean. Mr. President, you don't do not wrong anybody. He knows I don't mean you. So the government should ask for forgiveness for what it has done to these workers. What they did wasn't fair. And they knew better. They knew better because they heard from an expert telling them what they were doing was wrong. But what do? You ignore her. And now coming back a year after to revive the dead. I am still, I'm going to say the fifth time, you are trying to revive the dead. You cannot legally do what you want to do here. At least not in this way. You can't amend legislation that is no longer on the books. It is not there. What are you going to amend? But So if the government recognizes this and they say, well, they can stop now, I will sit down and you give me the assurance that we're not going to go back and come again. But what you need to do is to start rushing out, jumping to the whip of the people who you think matter. Because this legislation, I remember it was passed 1 week after a hotelier got up on Facebook and lambasted the government saying, I was promised that they're going to pass this thing in the House today, and they may pass it, so they're rushing to do a bill quick. That is why the same bill got so many mistakes. Short bill, too many mistakes. You talk out the tribunal, and then you still ask the tribunal to do certain things in the same bill. You say the tribunal can't deal with it, but yet still then you got certain sections you are saying when it goes to the tribunal, because you were rushing the crack of the whip from the people who matter to you. You know, it's amazing though, you know, when you're campaigning, the small man always matters. But as soon as you get the government, he matters in 4 years, coming up to the next election. So, sir, I think I've said enough to point out to you that the section that deals with the validation of claims can't work either. It says here in clause 3, any claims referred to in section 2.1, whether made before or after the commencement of this act, and any question as to the right of such an employee to severance payment, and to the amount of such payment referred to and determined by the tribunal pursuant to section 38 of the Severance Payment Act, cap 355A, shall be deemed to have been lawfully and validly referred, determined, and paid. I want to spend a very short time on this. This is saying that severance payments tribunals determined and paid claims under that old legislation that died. But that legislation said that Section 38 does not apply. And each tribunal, therefore, as I said earlier, has a lawyer as the chairman. So I want to know how this particular section of the Act got past the chairman, that the chairman didn't know that he had no authority to hear and determine any claims. And now we are trying to validate them. How could there? This is as plain as the nose on my face. The tribunal can't hear these cases, so what about hearing them for? The Act said you can't touch them. That the minister can put something in place, which they never did. But then you still went ahead and pay the people money. In other places, that would be called misappropriation of funds. Right? Or embezzlement. I didn't say that earlier though. So how are we going to fix that? How are we going to fix that? You see, this administration rushes to Parliament, and because of their large majority in the lower house, they do what they like, whether it's legal or not, and then seek to ignore what the law says, because this is not what you want. Mind you, you can change any law in Barbados, know the numbers that you got. So I don't understand why you would go and breach the law so call it violently, because it's done, it doesn't have any finesse. It's a brutish kind of thing. I call it more of a dictatorial type of behavior. I can do what I like. And this is what is happening in this country today. You need taking down, you know. Because when you give persons too much power, you know, it's a power corrupt. But absolute power corrupts absolutely. Well, this government has absolute power. And it has a tendency for using it without considering anybody else's feelings or what anybody else thinks or cares or what is even right. I still want to know how you're going to fix this legally. Because you can't ask the employers to pay the money because they can tell you no. And if they tell you no, you can't take them before the court. Because if you take them before the court, now we are having some nice decisions coming out of the court. She's just telling the government that they're misbehaving. So now you're going to have a problem. This is government's liability. Government got paid. But it shouldn't have been. They knew better. I can't even say it was deliberate. Because I'm sure if I said that, the president would call me to order. So I'm not going to say so, but I'm thinking it.
You know the rules now.
Yeah. And, sir, this does not make sense. It should not pass in this form. It can't sensibly pass in this form. But I don't want to accuse the government of having sense. So you will pass it. And then you can butt up on an employer or two who say, put me before the court, and owe you nothing. Because I don't owe nobody nothing now. You can make me owe them from tomorrow. Right? I hope that we never see anything like this again in this parliament during this session or any other session after that. The government used its majority with brutal force against the workers of this country, the people who are most vulnerable, because a lot of these people who work for a weekly wage or a paycheck are people who live paycheck to paycheck, you know. So when they miss one paycheck, people they're in poverty. So that severance pay that they were supposed to get, if the government didn't intervene to stop them, would have filled a hole somewhere, at least for a few more months. The last administration, when they sent home people, and they realized that there was no prospect for immediate employment, they extended the unemployment benefits from 26 weeks to 40 weeks. You didn't do that. You didn't care about the people you were hurting. You could have extended it for 40 weeks. But no, you stopped them from getting severance pay, and then didn't give them any ability to get more than 26 weeks. And as soon as the 26 weeks come back on, this is another aspect I've got to tell you about it. You know, you have employers calling people back to work because they don't want to pay severance. And when the employee serves a notice on them that they are claiming their severance, they then serve what they call a counter notice and tell them to come back to work. And have them about the hotel sitting down, doing nothing. No guests in the hotel, no work to be done. You sit down and they tell you at training. People just go to work and get paid for 3 days so that the employer would not have to pay severance pay. All compliments of the government that cares. That don't sound like caring to me. And I'm not talking about one or two hotels. I'm talking about a lot of them. This thing is widespread. Like the Planet when they had the meetings at the, what do you call it? At the association. Because all of them are doing it. We had one hotel in Barbados that told the workers, we are cutting your pay by 48%. And then tell people come back to work. You had barmen painting, cutting down bush with the hedges and stuff, and people frightened to stand up for their rights. That is why I recommended the sackcloth and ashes for the individual earlier, because they misled those people too. This amendment in 2020 has done more harm. It is not something that a Labour Party would do. A Labour Party, by its very name, should be looking out for Labour. You were looking out for the wrong people, and you hurt. You devastated the poor, the working poor, and then get them a care package. As a president, I'm appalled, and they're trying to come here without word about apology. You know, you hear people talking about reparations and people should apologize for slavery and all kind of stuff. I ain't hearing nobody apologizing for this. You know, this demands an apology now. Don't wait 10, 15, 20 years down the road and look back and say we want to apologize for what we did back then. Apologize now. And sit down with me and others and let me fix it, because it seems as though the government has no idea what to do when it comes to dealing with the workers, and the regulations deal with the employer. The only employees, they're only dealing with the employers. I cannot support a bill that is illegal. I cannot support a bill that is seeking to amend legislation that is no longer on the books. It is an amendment. Clause 4 says that you are substituting your words from one act and putting in something else. That is an amendment. Because if you did this now, you realize now that this section here, when you implemented it in the severance payment thing, don't make sense. LLB, I don't want one. I do a far better job. You know, I'll tell you something. I don't want to boast because they will come and beat me next time. I have not lost a case against any one of them yet. Yeah. But I have not come against them. So, Mr. President, this bill cannot pass or should not pass in this form. It is wrong. It's illegal. It makes a mockery of Parliament when you come and do something like this. You cannot, with a straight face, justify this. That is why in the lower house, nobody can speak on it. They were too ashamed. You know when you're ashamed, you do something. They were too ashamed to even debate it in the house. They let slide too fast and hope nobody would notice. And then put the poor leader up here to come and face me. Well, this is fast bowling. You can't face me on this because you won't got the bat. Might be yours. You know, this piece of legislation, they bring it and give it to you now and hope that you would get it through with the least bit of embarrassment to them. Well, I hold it up. I want the world to see what the Barbados Labour Party administration is doing in the name of governance and legislating. This could happen nowhere else. You know, if people outside of Barbados who know anything about parliamentary procedure and parliaments see this, they would laugh at us. He didn't say a word about it because he tell you that I will deal with it in the Senate. That's what he told them. I will deal with it because I'm more au fait with the legislation than he did. So he said he will leave it to me. And he has. You know, so he didn't say a word about it. Because you see, you can't be all knowing like you people out there, you know. You should listen to people sometimes. He ain't know everything.
But you do.
No, I don't. I know a lot of stuff, but I don't know everything. And they wouldn't man up. There were being boys out there. and he had to, you know. So man up on this one too. I admit that you were wrong. And fix it. Mr. President, I am much obliged to you, sir.
Thank you very much, Senator Franklin. Senator Tate.
Thank you, Mr. President. Sir, before I start my official submission, I'd just like to say I in no way exchange any funds with Senator Franklin in relation to my expertise and how often he said it in this chamber tonight. Mr. President, this evening, as is my habit, as other senators will tell you, I am going to submit to you basically a tale of three pieces of legislation. The bill before the Honorable Senate, which in its full name is referred to as the Temporary Right to Severance Payment for Layoff or Short Time Procedure for Settlement of Claims Act 2021, which I will refer to as Bill 2021. Then, Mr. President, there is the Severance Payments Amendment Act 2020, which I will call the 2020 Act. And of course, there's the Severance Payments Act, Chapter 355A of the Laws of Barbados, being the principal act. Mr. President, this evening, we are here to debate the 2021 bill. And as has been the case on numerous occasions in the past, it concerns me that the government has sought to introduce legislation to this honorable chamber to be considered and hopefully passed that has fundamental issues, and somehow it expects that it will not be challenged, or maybe it will still be passed. But for those of us who can read, and for those of us who do not want our legislature to descend any further into an arena of rejecting laws by the high courts of Barbados, I am here, sir, to highlight some of my concerns and to ask the government certain questions. Because I have said before, Mr. President, and you would not have heard me unless you listened to me on YouTube or on the Parliament television, Barbados is not a banana republic. So when we bring laws to our various chambers, they need to be lawful. The other concern I have, and I've spoken about this on numerous occasions, is the rushing. Rushing allows for errors, mistakes, incompleteness. The 2020 Act was rushed. The 2021 bill was rushed too, because we are debating it on the 19th of May, but it makes reference to an order of the minister for the 31st of May, which means between the 19th and the 30th, this needs to be passed so that the order can be made by the 31st of May. That means that there is no consideration for the possibility that it will not pass. There's little or no consideration for the possibility that it might have errors and or it may need to be redrafted. That concerns me, because this piece of legislation that has been brought before us, taken aside whether it's lawful or unlawful, is a very serious piece of legislation. Now, Mr. President, you will not know, but when the government brought the 2020 Act to the Parliament and the Senate on the 17th of June, I quarreled because we were getting it on the 17th. It was supposed to come into effect on the 1st of June, and it had a shelf life of the 31st of July, Mr. President. I also queried the absence of regulations, because it meant that no one really knew what to do about anything that the bills spoke to, because there was no proper guidance as to procedure. I asked, where were the regulations? Well, tonight we're dealing with these regulations. Mr. President, I tend to make direct reference to legislation when I'm making submissions. So if you would bear with me, sir. We have, sir, the commencement for the 2021 bill, which reads, Objects and Reasons. This bill would provide the procedure for investigating and settling claims made pursuant to the provisions of the Severance Payments Amendment Act 2020, and in brackets, Act 2020-15, which was enacted in consequence of the public health emergency declared by the proclamation given by the Governor General on the 20th day of March 2020. We are here more than a year later after that proclamation, dealing with regulations for a bill that came June 2020. No, Mr. President. No. That's flawed. Now, if I turned to the 2020 Act, and I go, sir, to clause 6B as it then was, it says, the minister may, by order, prescribe the procedure for investigating and settling claims. That's the 2020 Act. So we dealt with what the minister could do since the 2020 Act in June, but it wasn't done. I asked, it wasn't done. So my question is, Mr. President, by virtue of the fact that it wasn't done, is it that the government has time to waste, or is it that the plight of the numerous applicants who are displaced by either short time or layoff in excess of 22 weeks, their plight is not important? How is it that the government is only now getting around to dealing with the regulations that would make the 2020 Act functional and effective? Because one of the things that was peculiar about the sunset legislation, Mr. President, is that in order to qualify for severance, you had to satisfy certain conditions. In order to have those conditions satisfied, they had to be assessed. In order to do an assessment, you would have needed a tribunal. Mr. President, in relation to the issue of the tribunal, the Act of 2020 said at clause 6, as it then was, Section 38 of the Principal Act does not apply to claims made under these amendments. Section 38 of the Principal Act, sir, says, inter alia, any question arising under this act as to the right of an employee to a severance payment or as to the amount of a severance payment shall, in accordance with regulations made under this part, be referred to and determined by a tribunal appointed and constituted in accordance with the 6th schedule. So that section, by virtue of the 2020 Act, was deemed not to apply. So it stands to reason that a special tribunal was supposed to be set up to deal with the matters that arose pursuant to the sunset legislation. It is my understanding, Mr. President, that 2 tribunals attempted to hear matters, but determined that they could not do so. Other information from that department was that a special tribunal was supposed to be set up, and it had not yet been set up. So, how is it that we rush to Parliament, we rush to the Senate, and we have to pass this legislation because we're into the 17th day of its existence, and then almost a year to the day that it came into being, we are still without regulations. And it makes me wonder and begs the question if the importance of the 31st of May in the 2021 bill is to ensure that you have regulations in place before the anniversary of the date of the sunset legislation, which commenced on the 1st of June 2020. Is that the reason we're here rushing to get it done and happening by the 31st of May 2021? A year is still too long. That's why we're seeing people picketing outside. That's why we're seeing people picketing outside. Because NIS can't help anybody right now because there are no regulations in place by which they can assist. This is an abomination. You didn't have to listen to me, but you had a right to focus on your regulations. And the ministry that I believe that is responsible for these types of matters have more than one minister. So what are we busy doing? I'm concerned and I'm confused. To continue, Mr. President, it is important to note as well, Mr. President, that the 2020 Act also states at Clause 10, as it then was. Sir, I'm referring to the bill. I don't have access to the Act at this time. There may have been amendments. I doubt it very much. If there were amendments, they would have been very minor. But the substance is still the same with respect to the bill. Clause 10, as it then was, of the 2020 Act says, the 2020 Act bill, the amendments made by this Act to the Principal Act shall be deemed to have come into operation on the 1st day of June 2020 and shall cease to have effect on the 31st day of July 2020. Now, Senator Franklin had some fun talking about skeletons and death and so on. This is a serious thing. How is it that we are asking, by virtue of the 2021 bill, to make amendments to legislation that by its own wording cease to exist? What are you amending? I have taken a step further than Senator Franklin. I'm reading from the legislation. It says it shall cease with effect on the 31st day of July 2020. There's no dispute that persons are entitled to severance. That is not the issue. But we have to stop passing laws that can be struck down, struck out, laughed at, and kicked to the ground. We have to take time to do things properly. And with a lot of seats, with all the seats, depending on what you're counting and include, you have the personnel to get the job done. We can't keep bastardizing the law. We have to know what we are dealing with when we have it to deal with. We have to give the NIS, when they have the power to do so, compliments, be it Section 2G or whatever, the ability to go after persons who don't want to pay what they're supposed to pay. But you can't do it if you give them bad law to play with. The people who qualify should be paid their severance, Mr. President. But it can't be this way, because this is unlawful. And if somebody could show me differently, fine. But how are you seeking to place regulations onto law that has already expired? To use Senator Walker's, I think that's what he said, it expired. The other thing that concerns me, Mr. President, right? The 2020 Act had two types of persons that could qualify for this special severance. And these are people who would have been laid off or kept on short time between the 1st of March 2020 and the 1st of June 2020. It's a year. You don't have your regulations in place. You are making sport with people. And then you slip it in. You go to the lower house, somebody mentions it, there's no debate, it goes to committee, and it's up here. How is that possible with the amount of attorneys at law in the other place? How does it ring a bell? Send off some kind of alert. Are we sure we can do this? I'd be happy for somebody to show me how it would work, but I can't see how it would work because your legislation said it finished on July the 1st. You ain't even trying to pull this off August or September 2020. You are pulling it off or trying to pull it off on the first year anniversary of the sunset legislation, which by the very nature of the wording of the 2020 bill says temporary. It was temporary. It was sunset legislation. It was set peculiar to a set of persons who were affected at a particular time. The government has to do better. And I'm hearing Senator Franklin talking about an apology. An apology to somebody who has not gotten what they're entitled to for a year may not really sit well. It cannot be, Mr. President, that because you have all the numbers, you can do as you like because it can pass in the House, because if you have the numbers and it's a simple majority vote, it can pass. That can't be right. In the world that I work in, if I go to court and I have a client, I'm representing my client. If the person on the other side is unrepresented, there are times when the bench, be it the magistrate or the judge, will assist the individual so that they can flow a little better, get certain questions asked, certain procedures handled. And usually the lawyer on the other side does not object. But as an officer of the court, I am also required not to take undue advantage of the unrepresented person. Likewise, not because you have 30 plus seats, 29, however you want to call it, does it mean that you don't have to do the right thing, that you don't have to pay attention to detail, that you don't have to mind your constituents, no matter who wearing red or not. Because at the end of the day, Mr. President, you, to my mind, have a higher duty of care because you don't have a real opposition except what goes on in this Senate. You have no one calling you to account on anything unless it happens in this Senate. So you are required to do better. You are required to pay attention. You are required to mind your constituents' business. This offends me because I said it on the 17th of June. I told you what to do. I asked you where your regulations were. But you slip it in even though COVID was hitting us since February, March. We come in June, we late, and we had no regulations. We still do not have regulations, and we're trying to do a resurrection. Ascension Day was how long ago? I'm just saying. We got priests on this side, sir. It was last Thursday. This is what we doing? We doing Ascension? What we doing? The state to winner. The state to the government. We need Bev and Udine in here. Because this all this could be? Mr. President, no. No. Let's talk a minute, Mr. President, about this tribunal. If you, and what concerns me about this whole payment, I think that Senator Walcott made mention of payments that might have been made. I stand subject to correction, but I believe he would have alluded to the fact that certain payments might have been made already pursuant to the 2020 Act. I, like Mr. Franklin, would like to know on what basis, because the legislation makes provision for a tribunal to do so. It is my understanding, as I said earlier, that there has been no tribunal set up. So on what basis are you making the payments? Because here's the thing, Mr. President. If payments have been made to employees, whether justified or not, no, I shouldn't say that. If payments have been made to employees and an employer who wanted to have an opportunity to be heard has not been heard, you have a problem. That's a breach of natural justice. But ordinarily, the minute that an individual is paid severance, it becomes a liability to the employer. How you make an employer liable who can come and prove that they offered the person the job and the person didn't want to take it back? So how you get his severance from that employer? And what's the basis of his payment? Where's the decision? Where's the order? How are you going to get that happening in court? For you to recover the money that you're taking from the fund to pay people with a flawed procedure. Your validation clause tends to work when your legislation, when the principle is still intact. This government does a lot of validating. We backing. The Prime Minister says something in March. It's supposed to happen within 3 months. It's happening in 6 months, but we got a validation clause. So every piece of tax that happened beyond the 3 months, valid. I get it. That's how people run the business and the government. Fine. But how you validating something that you say finish?
Mr. President, on the point of order.
Yes,
A
Senator
point of what?
The honourable member is misquoting me or miss. She's saying that I said that every payments were made under this act, as she would say the 2020 Act. I said when I was speaking, Mr. President, that it is covering payments that were made long before COVID. These are things that go before this Act of 2020. That's all I said.
Thank you, Senator Walker.
But Mr. President, this legislation doesn't deal with the ones that were made before COVID, though. This legislation deals with the ones that are between the 1st of March and the 1st of June, the 22-week people. This legislation was done for those people who are about to run out of time because the Principal Act had severance for 13 weeks. After 13 weeks, if you're not called back to work, you're deemed to have been severed. This legislation sought to address that so that small businesses particularly, and businesses, because they couldn't call you back because we were in the throes of COVID, a lot of the hotels were closed. They added on the additional 9 weeks. So the ones before don't fall under this. The ones before COVID are covered by the Principal Act, Mr. President. This sunset legislation dealt with that group of persons. You get up so you can say it. The temporary right to severance payment for layoff or short time. Clause 6A, 1. Where an employee has been laid off or kept on short time, A, commencing at any time between the first day of March 2020 and the 30th day of April 2020, that employee will not be entitled to claim severance payment unless he has been laid off or kept on short time for 22 consecutive weeks or for a series of 18 or more weeks within a period of 24 weeks, etc., etc. That's 6A. Sorry. And clause 2 says, where an employee has been laid off or kept on short time before the first day of June as a result of the restrictions on international travel due to the declaration of a public health emergency and the consequent restriction in the operation of business imposed by the making of the Emergency Management COVID-19 Curfew numbers 1 to 5, Directives 2020, that employee shall not be entitled, etc., etc. These are the people, the 22-week people. And that is why it was so important. You had to set up some type of grouping, some type of entity, i.e. a tribunal, because in order to qualify under the sunset legislation, these type of persons, you had to prove that you were one of the or the other. So you needed assessment. That is to say, you needed the investigation and settling of claims. Before you could settle, Mr. President, you had to investigate, because under the sunset legislation, you had a peculiar group of persons, not peculiar as in odd, but a special type of persons who were affected directly by COVID. And that is why the whole issue of hearing matters or paying without hearing is dangerous, because you don't know, you have to have qualified. And if you're just paying without ensuring that the person is qualified, that concerns me. If there was a tribunal, if payments are being made, but all the parties are not being given an opportunity to be heard, I don't know if that's happening, but if it is, that concerns me. And I'm curious, Mr. President, as to how there can be payments if there's no tribunal established. And there can be no tribunal established because we know, looking to establish regulations that, among other things, would establish the tribunal. The duty of care must be higher because it is only you. It is only you. It is only the government. I do not believe, Mr. President, that this bill in its current form can stand, because it is seeking to give validity to that which has ceased to exist. I believe that fresh legislation, a new bill would have to be put before the Honorable House and the Senate in order to rectify the situation. The government, Mr. President, has to do better. I give the government points through by virtue of Senator Walcott coming here and saying, yeah, we didn't do it, so we're trying to fix it. It's going to be short. These are my words. He didn't say it, but this is how I received it before he got up and tell me that he didn't say it. This is my interpretation. So fine. My issue is, it ought not to have had to happen. This is too important a matter, and it is in everybody's line of sight. We're talking about persons. We've had members of the government senators coming and sharing with the House the plight of a number of these workers and how serious it is and how important it is and how terrible things are. And we know it. Everybody knows somebody who's going through a hard time. We're all going through hard times, I would be bold to say. So when you can make a difference and when you have something to do that impacts people's lives and their income, it behoves you to do the right thing and to do it effectively, efficiently, and within a proper time. A year is unacceptable. A year is an abomination. And then you are appeasing who by saying it must be done by the 31st of May? Who are you appeasing? You are putting pressure on the bodies who have to help with getting proper laws passed by saying, oh, well, let's just push it through because. No. This needs to be looked at differently because I am strongly of the view, subject to someone who would know or who can show me how you can ask for regulations to be put upon legislation that has ceased to exist. Apart from that, and you know what? Even if it's possible, that doesn't take away from the fact this should never have happened because persons' matters should have been adjudicated long ago. And I really hope that nobody is making payments without making sure that all the relevant parties are a part of the process, Mr. President. The government has 30 plus seats, 29, and others, consultants and everybody else, advisors, everybody is in the government right now. Handle your business is what I'm saying to the government, Mr. President. With those few words, sir, I'm obliged to you.
Thank you, Senator Tate. Senator Brandt.
Thank you, Mr. President. I really did not, sir, intend or expected that this bill would have required the need for an extensive debate. I must say, sir, that in a very simple way, when I looked at this bill, I thought that the purpose was to essentially ensure that a provision highlighted in the Severance Payments Amendment Act 2020 that had not been executed. The provision simply was in this piece of legislation to ensure that that action would in fact be executed. It was a matter, sir, that was debated at length in this chamber. It was a matter, sir, that was passed by this chamber. And unfortunately, as the leader of government business indicated, the action which was required in terms of the order being made by the minister was not done. And that, sir, is the reason why we are here today and the reason why we have this bill before this chamber for consideration. I heard some comments in this debate, sir, that amazed me. In fact, sir, maybe I should not be amazed by comments coming from a particular senator, where the suggestion is being made that the government has done harm to the people. Where a suggestion is being made, sir, that the government used its majority against the workers in the country. When the reality is, sir, that the government sought through legislation to ensure that it could protect the workers of this country. The legislation, sir, was not intended to harm the workers or to remove the rights of the workers, but to protect, sir, the workers of this country, as well as to protect and to ensure the survival of those workers and the survival of businesses. Mr. President, when I listened to the contribution from Senator Franklin, I thought to myself, Senator Franklin must not recognize that we are existing in an environment where we have been impacted by the ravages of COVID-19. And there was a situation, sir, where businesses in Barbados, and not just tourism enterprises, because a lot of tourism enterprises were impacted. A lot of hotels in a very significant way saw a loss to revenue, but the recognition also was that a lot of other businesses also depended on tourism. And the impact was severe. Sir, don't take my word for it. I'm going to reflect on some numbers. I've done it before in this chamber. I'll do it again. Mr. President, in January of 2020, just to give you some figures, the revenues earned were in the vicinity of $112 million with respect to hotels that would have been reporting in relation to that month. Sir, by March of 2020, there was a 41.2% decline over March of 2019, where revenues were at $64.5 million. Sir, in July, which saw a reduction in occupancy of 90%, the revenue, sir, was $1.9 million. Sir, you know, in the month of April, we saw an increase in revenues. And the figure, the percentage, sir, will sound big. A percentage of increase of 229%. And the figures sound big, but sir, when you look at the dollars, when you look at the actual money, sir, you know, the monies is not a lot. It moved from $1.7 million in April of 2020 to $5.7 million in April of 2021. And in April of 2019, sir, it was $78.7 million. I start there, sir, because we have to put things in context. Mr. President, these are not normal days. These are not normal times. And the government has a responsibility to ensure that there's the survival of individuals and that businesses also can survive so that workers can continue to work. And the reality is that there are a lot of businesses that do not have the monies available to pay a severance. But sir, it's more than that, you know. It's more than that. I was involved in the discussions with respect to the amendments to the what was referred to as the 2020 Act. And one of the things that was recognized was that facilitating severance would not necessarily be the answer, because persons, yes, could get what they consider to be a lump sum of money, but that money, sir, would not necessarily last for a considerable amount of time. And the recognition was that it was more important to make sure that people continued to work and to facilitate being able to get some money, even if it was not the full extent of what people got before, than to have this lump sum of money, sir, that would not last for a long time. So when Senator Franklin comes into this chamber and seeks to give the impression that the government of Barbados is doing nothing, or that the government of Barbados is instituting measures to hurt the workers, he is misrepresenting the truth, sir, because that is not the case. The government of Barbados brought the BEST program. The BEST program, sir, has as a fundamental aspect of it the re-engagement of workers. Any entity, any tourism entity that is participating in the BEST program has first to commit to the re-engagement of workers. And that re-engagement, sir, is at 80% of the annualized wages for 2019. That 80%, sir, is better than what is required if a person is laid off for 13 weeks. And if I am not correct, the experts can guide me. But when a person is laid off for 13 weeks and they are re-engaged, the obligation is that they be provided at least a minimum of 3 out of 5 days. That is my understanding, for a period of at least 26 weeks. Because if they are not engaged for that period, then they still have the right to severance. I do not understand where this notion has come from, and this claim that there are persons who would have been earning $1,000 a week. I wrote it down, sir. Persons earning $1,000 now working for $100. And I said to Senator Franklin, if you make that claim, bring the facts, bring the information. You too often stand in this chamber and you make allegations, and you do not substantiate those allegations which you make with facts. And I say to him, bring the facts. It is okay to get up in this chamber and to talk and to make those allegations. But I want, sir, when he does that, for him to substantiate it. Because as far as I'm aware, if an employer re-engages an employee and pays that employee less than 3 out of 5 days, then what is required is that the employee could claim severance. That is my understanding. And if I'm incorrect, those who are better versed in this area can advise me. But I also heard Senator Franklin saying that there were people who were waiters and they do a little painting here and I had to help out there. Sorry, go back to where it started, you know. These are not easy times. These are difficult times. And while it is clearly understood that persons should be offered re-engagement, offered jobs that would be keeping with what they would have been doing previously. Sir, I think that workers themselves understand, based on the feedback that I've had, that this is a time when some of them may be required to chip in and to do things that might not have been required in terms of their job description, but for which they are prepared to give some assistance. And sir, I must say that I see nothing wrong with that. Because, you know, if the business fails, then everybody is challenged. Sir, I well remember I was functioning, and I may have said it in this chamber before, I was functioning as senior consultant in the Ministry of Industry and International Business. There was a matter, sir. In fact, sir, you will well remember the matter because you functioned in that ministry and in the ministerial capacity, sir. And we dealt with a matter, sir, where a soft drink manufacturer had a situation where employees for 15 minutes, I remember it well, 15 minutes would look at bottles going around. And then they had another hour and 45 minutes where they did nothing. And the soft drink manufacturer sought to get the agreement of the union to allow those workers to be able to engage in another task because they felt, and I think justifiably so, that just sitting and playing dominoes and cards was not the best use of the resources, the human resources which they had. And it stands with me, sir, because that was not agreed to. The business, sir, ended up closing. That, in the end, the business closed. That hurt. The employees hurt because they didn't get any more wages. And I'm saying to this chamber, sir, that at a time when we have this abnormal situation brought about by COVID-19, I'm saying, sir, that it's important that we do not act and behave as if these are normal times. Mr. President, these are not normal times. Sir, I come into this chamber and I have to wear my mask. Sir, I have to social distance, sir. We are accustomed, sir, when we meet and greet some of our colleagues to hug and embrace. That has not happened, sir, for a long time. We have to bounce because this is the environment that we are in. And let us therefore, when we speak to issues such as these, recognize that the times we are in cannot be dictated in the manner in which we would have in 2019 or 2018 or 2017. It requires that we function a little differently. Mr. Chairman, reference was made to the BEST program. And the statement was made that the BEST program is the worst program possible. Took the money, persons, businesses took the money and not getting service charge. Again, I say, sir, that is not true. It is simply, sir, not true. Tourism enterprises that apply under the BEST program to the Enterprise Growth Fund Limited are required, sir, to pay 80% of the 2019 annualized earnings inclusive of service charge. Sir, I'm going to repeat it again because I want those who make the claims in this chamber to come with some facts and to stop saying things which do not represent the facts. Any tourism enterprise approved under the BEST program in terms of the wages and salaries must provide 80% of the 2019 annualized earnings inclusive of service charge. So it is not true, sir, not true at all, to say that there are persons who are not paying service charge. And I'll tell you this, sir. At present in the hotels, there are not a lot of visitors, so there's not a lot of service charge. If the service charge had to be in relation to what is collected now, the service charge would actually be less than what the workers are being paid. So that it is incorrect to give the impression that the workers are being penalized by this government. The issue was referenced as well about persons going to work and only engaged in training. Sir, this is a downtime. Last month, the occupancy was 15.5%. In February, 15.6%. In April, 14.8%. Sir, the occupancy of hotels is in the vicinity of 15%. In fact, the anticipation is that we are going to see a summer that is, at this moment, the summer period is soft. There's not a lot of activity, although I know that there are some actions being undertaken by the Barbados Tourism Marketing Inc. And the expectation, however, is that winter will be good, or will be, we expect a reasonable winter, because based on the discussions we have had with tour operators, the winter period is booking well, and 2021 is also booking well. But today, there are not a lot of visitors in Barbados. And the determination was made that what we need to do is ensure that we are able to upskill our workers through training. Now, I do admit that we probably need to enhance that and to better execute that. But there's no doubt that when tourism comes back, when people are able to travel again, when Barbados is on the green list, and when other countries are seeking, sir, to get visitors to come to their destination, there is absolutely no doubt that we have to ensure that we are able to provide good value for money. And having workers that their skills are enhanced, I think, sir, is a very positive and good thing. Not going to spend too long, sir, because the hour is getting late, but the program provides for digitization. Digitization of processes, allowing companies to be able to get money to assist with transformation. The program, sir, allows for a greening component. All elements, sir, that are critical and are important. The program, sir, allows for investment dollars to be provided so that you can enhance the value of what you have, enhance the product offering, whether it be by way of furniture, equipment, new infrastructure. It is not a program, sir, that is not without the desire and the intention to ensure that tourism enterprises are better and that workers themselves are in a better place, Mr. President. So I felt it necessary, sir, to speak briefly in this debate, because I would not want this chamber to be left with the impression that businesses, tourism enterprises in particular, are taking advantage of workers. I would not want the impression to be given that the government is seeking to execute actions that would be harmful to visitors, to workers, sorry. I would not want it to be accepted that there were workers getting $1,000 a week now getting $100 a week, because I have absolutely no knowledge, and if that is the case, I would want the facts, sir, to be brought to us. So, sir, I end where he started. To me, sir, this bill is a simple bill. A bill to ensure that an action required under the Severance Payments Amendment Act 2020, that action is executed and that we are able to fulfill the obligation as required under that act. And I believe, sir, that on that basis, that we should all support this piece of legislation. I'm obliged to you, sir.
Thank you, Senator Grant. Any other speakers? Senator Hunt.
Thank you, sir. I rise to make my contribution to the discussion of the bill before us. Being the newest member of this chamber, I did not have the first-hand benefit of having been present 1 year ago when the Severance Payment Act was amended, which amendment is the reason why we are here at this hour. In matters like this, context is always important. So I believe I had to do a bit of preparatory work beyond which my colleague senators had to do. I think that's foreseeable. And the journey to this moment, it caused me to, in my search for context, to doubt myself, to doubt whether what I was reading, to doubt whether my understanding of what I was reading in this bill was accurate. One plus that came from that exercise is it reminded me of one of my favorite poems by Robert Graves, which I will not rely on my ability to recall at this time, and therefore would crave your indulgence if I lean on the help of technology. It says that he is quick, thinking in clear images. I am slow, thinking in broken images. He becomes dull, trusting to his clear images. I become sharp, mistrusting my broken images. Trusting his images, he assumes their relevance. Mistrusting my images, I question their relevance. Assuming their relevance, he assumes the fact. Questioning their relevance, I question the fact. When the fact fails him, he questions his senses. When the facts fails me, I approve my senses. He continues quick and dull in his clear images. I continue slow and sharp in my broken images. He, in a new confusion of his understanding, I, in a new understanding of my confusion. And that pretty much sums up the position that I was put in, preparing to contribute to this debate when I considered what we're really looking at. Now, I have enjoyed the contributions made by my colleague senators today, and at this point, I am happy to be able to benefit from contributions made by some of them, because there are overlaps in what I had prepared to contribute and what has gone before. So I need not belabor certain points. However, there are some things which I believe are so important that they need to be repeated. Now, when Senator Grant spoke just now, early in his presentation, he indicated that he really saw no need or perceived no need for extensive debate. And then he listed the reasons why that is his perception. And I'm of the view that the government also perceived no need for extensive debate of this bill. Because when I looked at this bill's treatment recently in the House of Assembly, I noticed that the Member of Parliament for Christchurch East Central, in leading the second reading of the bill, referred to it in terms of an amendment just to provide the validity with respect to the process that had been outlined, and just to allow the national insurance scheme to tidy up the process administratively. I do not think that the level of seriousness which the implications of this bill brings has been realized. But context is a heck of a thing. There is a lot of misconception out there surrounding the issue of severance pay, the entitlement to severance pay. Right? There are perceptions that some people have that they can resign their job and be automatically entitled to it. They'll get it. Some people think that if some person or other entity buys the entity they work with, there's a right to get severance in Barbados. But Section 3 of the Severance Payments Act outlines clearly for anybody to see the circumstances which give right to an entitlement to severance. When a person is dismissed due to redundancy, when a person is dismissed because of a natural disaster, or when a person is laid off or kept on short time to the extent set out in Section 6 of the Principal Act as referred to by Senator Tate when she spoke. And it was last June 2020, that is, amendment of the Severance Payment Act, and how we treat the efforts, or what were to be the intended effect of that brings us here. Some of the important themes which I believe need to be dealt with as it relates to this bill have to do with the legality, questions of the legality about what the Parliament is seemingly on a road to doing. I have served as a member of NIS tribunals, not severance payment tribunals, but benefit tribunals nonetheless. And I've noticed some things about tribunals. They don't use a process which is very, very formal. Applicants do not need legal representation to get what they deserve. Claimants come, how the tribunals work, claimants come, they state their case. Respondents come and state their case. The tribunal then assesses whether the applicant is qualified for what they're applied for and makes an order accordingly. In other words, the business of tribunals, the business is done according to principles of natural justice. And that factors significantly here in the context of this bill. Because it is on the basis of a tribunal decision that an employer is made to know whether he has culpability, whether he has liability, or not. Now, naturally, I have some questions that arise as a consequence of how tribunals are set up and expected to function within the context of our legal system. I noticed that when the 2020 amendment was debated, both trade unionists present in this chamber agreed on a number of things. One of the things that was mentioned by one of those trade unionists was the impressive extent to which the government had been communicating with the public. Nobody can fault the government as far as its record on communication goes. In fact, feedback from the public has sometimes been along the lines that government is not communicating, but that government is communicating. That they're hearing the same thing too often, or hearing the same people too often. But there are certain issues about which there's too little communication. And those issues have to do too often with the state of the labor market. Whether it is the unemployment rate, or whether it is information which ties directly to the workings of the Severance Payment Tribunal, such as when we consider the period of time during which the qualifying period for persons who were on layoff was extended to, in one instance, 22 weeks, 22 consecutive weeks. Is anybody in a position to let us know if any employees who qualified to receive severance pay during that period received any severance payment? Now, to me, the significance of that is this. If I am an employer and I had laid off staff for 22 or more weeks, I would be interested in knowing if a decision was made that those employees are entitled to receive severance pay. I would especially be interested in knowing if that happened through some means, via some forum that I was excluded from. Because if the tribunal was not empowered to meet, to hear such applications and to make decisions, on what basis would such a consideration, a determination have been made? And it had been said all over that the government was intent on making sure persons who are so entitled receive their payments. And the expectation was that the NIS would then seek to recover what was paid out from employers. Now, if a decision such as that, which was adverse to the interests of an employer, was made, can it stand in law? And is it right for a parliament centuries old and therefore expected to exhibit a certain level of maturity to be behaving like this? Clearly, it's a rhetorical question. The answer is no. Now, another feature of the bill which concerned me is that it appears as if we are seeking to make amendments to sections that are no longer in force. And they're no longer in force because they were sunset provisions. And once a certain time on a certain day passed, they no longer were effective. It confounds the mind. If it is that we're saying that is what we are actually about, you know, is it that, I mean, today there were numerous references to the dead, and I mean, simply as an exercise in coincidence, this seemed to me, as I recorded it, to be an exercise in necromantic legislating. Having had a mixture of Pentecostal and Anglican upbringing, I was told there's certain things I was never to dabble with. You know? But these are things which concern me. And I find no comfort in the fact that part of this bill seeks to carry a clause of the nature of a promise with respect to an order that the minister may use to prescribe a procedure for investigating and settling claims. This responsibility on the part of the minister is nothing new. It existed last year, a year ago in the 2020 amendment. He did not make the order last year. And with 12 days left for the minister to make this order, after how last year went, it doesn't inspire any confidence. Senator Rogers could perhaps tell him that he needed to be faithful in small things if he wanted to be trusted with greater things. Sir, generally, the concerns I've raised, as they overlap with the concerns raised by other senators, particularly Senators Franklin and Tate, to my mind, come together to display this bill as not being presented at this time in a form which should be passed. I'd like to touch on another matter, sir, because I noticed Senator Walker in his introductory remarks. He referred to what measures the government of Barbados was making to assist the Barbadians employed by LIAT. That is a good gesture that I think the government should be acknowledged for. And it certainly is an initiative that I support. However, LIAT is a company that has as majority shareholders Barbados Antigua and Barbuda, the St. Vincent and the Grenadines. LIAT is important to the bringing into reality this ideal of a Caribbean community. Barbados needs LIAT. The other countries in the Eastern Caribbean need LIAT. Employment conditions, national insurance schemes, national insurance ethos is not the same across the Eastern Caribbean. Barbados has a model that is superior in a lot of ways when compared to other territories. It is regrettable that any worker should find themselves in a position where they are unable to work through no fault of their own, circumstances as this where they should be able to access unemployment benefits and or severance, but they cannot for whatever reason. The Barbadian workers who are employed by LIAT find themselves, unfortunately, in that position. It is time that we start to think about, but not think too long. Think and then get to work, making certain things that we think about reality. It is time that we start to think about whether there should not be something of some regional provision for severance for workers who have employment of a regional character. From time to time, there have been talks about the possibility of reciprocal arrangements between one government and another. But I think that LIAT, because of what LIAT is, because of why LIAT is acknowledged as being important to the region, something better has to be done to safeguard workers who work for that company, which has a regional character. As a majority shareholder, I'm happy that Barbados has stepped up and has acted on its moral obligation towards those workers, but I would really like to see a movement from a place of moral obligation to a formal legal obligation that offers the necessary social protection for that cadre of workers. So, with those words, sir, I am obliged to you.
Thank you very much, Senator Hunt. Senator Walcott. Oh. Senator Cummins.
Thank you very much, Mr. Chairman. Under ordinary circumstances, this is not a bill on which I would rise to speak. I am not, like my colleague, Senator Franklin, my friend, Senator Franklin, my nemesis, Senator Franklin, industrial relations expert, a lawyer, a former immigration officer, a customs officer, all kinds of things. I am not any of those things, and so I would not typically speak on a matter like this. I would not. I am not, like other colleagues, either schooled in the legal rudiments of industrial relations law, national insurance law, the treatment of severance tribunals, as my colleague just spoke in great detail about how they are executed. And I would not ordinarily venture into those waters because I typically tend to stay in my lane. I know others venture into everybody else's lane, but I tend to stay in mine. But on this occasion, I rose, Mr. President, to speak to three very specific issues. I rose to speak without repeating what my colleague, Senator Grant from the Barbados Hotel and Tourism Association has gone into great detail on the operations of the BEST program, but I will speak a little bit about the BEST program. I will also speak a little bit on the last matter raised by Senator Hunt on the question of LEAT. And ultimately, I want to speak on the position of the government of Barbados under this administration on the treatment of workers and labor in this country, because I believe that it would be remiss of me, given the fact that this particular item of legislation, whatever the legal issues being presented by my colleagues are, whatever the procedural issues being raised by my colleagues are, specifically speak to 35,000 workers in a sector that I hold responsibility for. And it would be remiss of me to remain seated and not to rise on this occasion to speak on their behalf. Now, let me start by saying, Mr. President, that the BEST program is a $300 million program. Of that amount, $207 million have been allocated for the wages component. How is that possible for an administration that is focused on employees? There is a $150 million allocation for the investment component. Of that, $50 million comes from the private sector. More than 50% and over of this program, almost 60% of this program, the BEST program, is earmarked as a wages subsidy for employees. But there is more, because Senator Grant spoke to it earlier. If a hotel is closed, and it is closed for as long as we have been dealing with COVID from February 2020 until now into 2021, and we're already talking about our projections into 2022, what would be the nature of the physical plant that a worker would have to come back to? What would be the nature of their mindset if they're not being provided with the training that is incorporated under this program and being facilitated by the National Transformation Initiative? What will be the nature of the hotel infrastructure if air conditioning units are not being maintained and serviced? If we're not preparing under the circumstances, notwithstanding what's happening in the source markets, for the return of visitors? We've been talking as a nation about climate resilience and vulnerability and ensuring that the tourism industry leaves a smaller footprint on the globe. What would be the impact of a closure on a hotel rather than investing instead in renewable energy and ensuring that they have access to investment in renewables? What would be the nature of our position in when the market resumes if we did not take this time to invest in digitalization? Making sure that our facilities, our people, our infrastructure, the mechanisms and the procedures and processes that all are part of the tourism industry, particularly the accommodation and the direct tourism services sectors, that they are fit for purpose at the time of resumption. What would be the case if we were to just literally stand still and say, never mind crafting a program that treats with the whole of the sector? We are instead going to replenish the severance fund on its own, put that amount of money in the severance fund, let people stay at home, deal with the mental health challenges that are inevitably going to come as they sit and they contemplate the absence of a future, the absence of prospects, and the limited income, because when you get that lump sum of money, you have things that you have to get done. And when that starts to dwindle, and people are sitting at home and they're not training, they're not getting out there, it starts to eat at you. It starts to become a part of your psyche, that hopelessness, that frustration. Those are the people that we're dealing with. So while there may be those in this chamber who are comfortable with the idea of putting money simply in a severance fund and disbanding with a BEST program that deals with the whole apparatus of the sector, that is not the way of the Barbados Labour Party. That is not the way of this administration. That is not what we are about. What is being proposed as the alternative is not in the interests of people. It's not in the interest of labor. It's not in the interest of workers, and it certainly is not in the interest of the tourism sector. Because what you will find by the time the market returns is that hotel plants have become dilapidated. How many of us have left houses and seen houses where no one lives in them, no one visits them, and the faster they deteriorate faster than anything else because nothing is happening in that house? What would happen if we did that to our tourism product? And then we will be accused as a government of not preparing for the resumption of tourism. Then we will be accused as an administration of not anticipating that which could have been foreseen, reasonably so. But instead, we are preparing for that. We are mitigating against the impact of what we're dealing with now, but we are still positioning people so that they have an opportunity, one, to earn 80% of their reinsurable earnings, that they have an opportunity where the property is not in a position to pay, to appeal through the various mechanisms that have been outlined. We have been supporting businesses because, let us be very clear, there has been this antagonism that has been stoked from some quarters, including in this place, that business is bad, people are good, workers are good, employers are bad. Where there are no employers or no businesses, there would be no employees. And so there has to be an equal balance between ensuring that workers are kept employed and are kept maintained, even if it is at 80%, and that the employers who will give them their jobs back when they come back to work remain with their heads above water. There has to be a balanced approach. This myopia that we typically come with these off-the-cuff, superficial approaches that don't mean anything in the real world, have to come to an end, because that's not where we are. That's not who we must be. We have to find a way to create the balance where the private sector grows, businesses grow so that they can employ more people, because government does not earn any money from anything unless there is commercial and economic activity in a country. And so people will not have an opportunity to be employed if we do not find a way to create the balance between a wages subsidy and an investment in businesses to keep them afloat. That is the nature of what running a country and governance and management and foresight means for everybody. Without unions, without workers, there would be no unions. And without created controversies, there would be no membership forms to hand out. So, for membership and membership dues, Mr. President, we have to be realistic about what we're doing here. And so I am supportive of what we have done as an administration. It is what had to be done, and there are 35,000 workers out there that still are hoping that we are in a position to meet them where they are. Now, on the question of LIAC, I want to share some numbers with you here, because it is easy to sit in these spaces and make off-the-cuff remarks without having any substantial facts to back them up. It is the easiest thing for people to do, but I don't have that luxury. The government of Barbados, when we assessed the exposure for LIAT workers who were entitled, who paid their dues over how many ever years into Antigua in particular, and those that paid into Barbados, the total liability for LIAT workers was estimated at $14.87 million. $14.87 million. That includes their vacation pay, their lieu of notice, and their severance payments. And that is for just approximately 91 Barbadian and Barbados-based employees of LIAT. They are Barbadian. They are Barbadian. They are our neighbors, our sisters, our brothers. And what they are dealing with is a legitimate issue that needed a response. And a government that has already said to the public by way of its estimates of expenditure for the financial year 2021-2022 that we have seen an absolute decline in our major revenue earner, the tourism sector. And we have seen a decline in exports as reported recently. A government that has said that the only thing that has kept us afloat is the fact that we managed successfully before 2019 to close the fiscal gap and to put a number of measures in place that allowed us to have a cushion, and also was able to create changes in our international business regime where our corporation tax then meant that our international business receipts kept us afloat. A government that still is dealing with soaring social expenditure to look after people in the face of plummeting revenue is being accused simultaneously of not caring for people. How is this possible? A government that made a determination that for the small people who were working in shops and bars all around this country who had to close as a result of a pandemic that no one in this country, no one in this room created, certainly no one in the Barbados Labour Party administration, but given some of the conspiracy theories that come out of this place, who would imagine what will be said next? We still found a way to support thousands of small shops and small entrepreneurs in this country. We still found a way for the nail technicians, to the bar owners, to the hairdressers, whoever, to support them, to the fishermen. This is a government that is being accused of not looking out for workers. How is that possible? I could not stay in my seat, Mr. President, and allow those things to stand. It is not possible. So we made the decision as an administration that even though the entity, LIAT, is legally liable for the severance, vacation, and the lieu of notice pay, and we are still calling on the administrators of LIAT to do what is right by these workers who flew night and day up and down this Caribbean, bringing us from one place to the other to do the right thing and honor the liability which they have to these workers. The government of Barbados still, despite all that it has been facing, despite all of the revenues that have vanished and all the expenditures that have been increased, in particular on social spending, still took up $2.8 million and allocated on top of the $207 million that I just spoke about invest, and said, here is an ex gratia payment for LIAT workers. This is a government that does not care. Tell me one instance where a previous administration would have, in these same circumstances, done the kind of social spending that this administration has done. Tell me one, Mr. President. Not one. There are none others, Mr. President, not under these conditions. Even when the conditions were fine or they were better, none of these programs existed, Mr. President. We took up taxi workers, people with 14-seaters, and said, look, we know that you are assigned to the port, you were assigned to here, come and be a part of the transport augmentation program because you have a right to earn. This is an administration that doesn't care about people and their livelihoods. Yes, give it a vote and watch me. They're watching us, Mr. President. They're watching all that we have been doing and continue to do for this country and for these people. And I'm not saying that there are not mistakes, Mr. President. There are. I'm not saying that there's not hurt, because there is. I'm not saying that people are not struggling, because they are. You just have to walk through our communities. You just have to hear what's happening to people. I see them, I feel them, I hear them all the time, Mr. President. On Friday morning, for example, I'm spending some time with another group who have some grievances because I want to be able to hear what is happening, because I don't want them to be snatched up into the ravages of those who want to create controversy for their own benefit. So we have to try to diffuse those things before and meet people where they are. We see those things, Mr. President. And I'm not saying that every item of legislation is going to be perfect, because I am saying to you very clearly that there are many workers who have suffered because these issues have taken so long. I would want to see those things resolved far quicker than they have been. And I am supportive of the setting up of these tribunals for LIAT, for those persons who did pay into the severance scheme. A dedicated tribunal is being set up, and that will be looked at. But, Mr. President, my final comment that I want to make today is this. We have to find a way in this environment. We have to find a way in this environment. People are struggling. People are frustrated. People have COVID fever. People feel as though it's been so much for so long. When the ash came, you felt as though, oh gosh, man, one more now. We're going into hurricane season. We have no idea, because we are not Jesus Christ or Nostradamus or anything else. We don't know what this most active hurricane season is going to bring. We don't know what it is going to result in for the tourism sector or for our workforce. But what we do know is that this is a time where we have to be committed, not just to doing the right things in the right ways for the right reasons, but where we have to be committed to lifting each other up and stop with all this divisiveness and this inflammatory rhetoric and this personalization of our partisan preferences masquerading as commentary on substantive issues. Let us be real about what we're dealing with. Let us not hide behind the cloak of independence and technical capability, because we know that a lot of this, at the root of this, is very much partisanship. There are people who have political ambitions of their own. None. Don't have anything to say to me. So you have people who have an agenda, and what they're doing is they are taking those workers who are legitimately hurting, legitimately frustrated, legitimately hoping that there's going to be a resolution at the end of the tunnel for them, and they are stoking them up with false rhetoric, leading them down the garden path. Mr. President, I cry shame on them. This is not the time for that. People tired already, Mr. President. Everybody fatigued. Everybody is fatigued. Me too. Everybody is fatigued. This is not an easy time. And so what I know that there are those in here who take pleasure in riling things up because they get a direct benefit. Again, I say, as I said at the very beginning of this entire debacle in 2020, February, this is not the time. It was not the time then. It is not the time now. As we continue to navigate this season, it will not be the time going forward either, because history will record, with or without our rhetoric, what this administration has done in support of workers. History will record what we have done for tourism workers. History will record what we have done for shops and businessmen and transport operators and taxis. It will record it. And I am proud to put my name to the work that has been done by this administration, and it is for that reason, Mr. President, that despite not being an expert in the rudiments of industrial relations or one of the legal luminaries in the room, that I rose on this occasion to speak to the matter of this bill and to cite the importance of us going beyond our narrow little one-dimensional perspective that says this has not been done in this straight way, but we are going to cause so many other people to struggle and suffer because we don't want to come to the table and work with others to create the best possible way to get it done in the interest of the people we say we want to support. Mr. President, I give this amendment my support. I regret that it has come in this way and at this time, but I'm committed in the interest of the people we serve to getting it through the Senate today. And with those few words, Mr. President, I'm obliged to you.
Thank you, Senator Cummings. Senator Boyce. Right, please.
I rise to join the fray, Mr. President. In this context, imagine being a 3-year veteran saying that we have been down this path before, somewhat before your time, Mr. President. And what we have is we see a dialogue of persons with perspectives, and this is what the Senate is for, to engage in that dialogue while we seek to come to some form of understanding or at least a way forward. I was comforted when I heard the words with which Minister Cummings ended in when we seek to work with others. The fact of the matter is, Mr. President, if persons raise concerns with legislation which is brought, and the concerns, when we can look at them objectively, have an element of validity, does it not then beg the question of how we can find a resolution to those concerns instead of them being labeled and painted in a way to indicate there is an unwillingness or an acceptance to find the common ground, sir? Senator Tate has pointed out, and I must confess it did not occur to me, Senator Tate has pointed out, Mr. President, that there is a fairly serious defect with regard to the giving a change to the powers of the previous act. I have sat down, Mr. President, and I believe that there is a solution which could be found wherein perhaps there can be an amendment to the previous act which is still in force and the time period by which the act is to have effect extended so as to allow this act to pass, and therefore they both mesh. Or perhaps we can pause on the vote for this act and give ourselves time to amend the other one, or perhaps edit this act to make a reflection with regard to when it is to commence, so that we have a scenario where you have a duality going forward. But instead, Mr. President, what we hear are almost, it is supposed to redound to the benefit of others, therefore it ought to pass. But objectively, why is it now being come to say that it has to redound to the benefit of others now? Why was it not done prior? Why are there no alternatives? It is somewhat frustrating when any attempt which is made to have an objective critique is painted with partisanship. For my part, I have had to deal with a lot of stuff, Mr. President, because I take a certain stand, and I can keep very quiet and say nothing. But it cannot be that if you have a position which does not align with the majority, that your position has to be painted as one which does not have a certain meaningfulness or goodness in terms of what you're seeking to achieve. Senator Tate has said, guys, let us fix this. There are issues with it. There is an opportunity. We can stop at this time. When it goes to committee, we can look at amendment to make the legislation on all fours. There is a majority. It is the 19th of May. We can get this done. So I rise very simply, Mr. President, to urge all members of this House to use their best efforts in coming to a solution which will allow the objectives of the government to be met, but to be mindful that in doing something, at the end of the day, the ends do not always justify the means. And this has been an issue which we have raised in this House prior, Mr. President. And with that, sir, I hope someone will listen. Thank you, Mr. President.
Thank you very much, Senator Boyce. Senator Walcott.
Thank you, Mr. President. I want to thank all honorable members on this side who have spoken. I've noted the comments of the honorable members on the other side, and I beg to move that this bill be now passed a second time.
The question is that this bill be read a second time. Those honorable senators in favor, please say aye. Those against, please. Those against, please say no. Sorry? A division has been called. Sorry? Yes. Yes. Sorry. Yes. Okay. They think the ayes have it. Yes. I was just one step ahead of myself. I had heard the calls there. A division has been called for. yeah, at everything. Yeah, yeah.
Ready, sir.
Go ahead, go ahead.
Senator Walker.
Aye.
Senator McConney.
Aye.
Senator Cummins.
Aye.
Senator Dr. Springer.
Aye.
Senator Dr. Holder.
Aye.
Senator Adams.
Aye.
Senator Dr. Haynes. Senator Grant.
Aye.
Senator Sands.
Aye.
His Honor Senator Greenwich.
Aye.
Senator Franklin.
No.
Senator Drake.
No.
Senator Wiggins. Senator Reverend Dr. Rogers.
No.
Senator Hunt.
No.
Senator Nurse. Senator Nurse. Senator Nurse, please. You have to abstain. Senator Boyce.
Abstain, sir.
Senator Boyce?
Abstention, sir.
Okay. Senator Maynard.
No.
Senator Tate.
No.
What are the numbers again? Mr. President, the result of division on the second reading, 10 honorable senators voted in favor. There were 6 who voted against and 2 abstentions. And therefore, the majority, the second reading is thus.
Senator Walcott.
Mr. President, I beg that Your Honor do now leave the chair and the Senate resolve itself into committee for further consideration of this bill. Thank you.
The question is that it do now leave the chair. And the Honorable Senate resolve to serve in the committee for further consideration of this bill. Those honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
11 members who voted in favor.
Thank you for your accuracy of the count. The Senate is therefore now in committee.
The Senate is now in committee.
I beg to move that clause 1 stand part.
Mr. Chairman.
Question is that
Mr. Chairman, sorry, when you're suggesting the amendments, do you do it at this stage, correct, Mr. Chairman? Or do I wait until?
Yeah, you do at this stage.
Right. So, Mr. Chairman, in light of the previous statements made and in light of the eagerness of all the honorable members of this House to get a resolution which will be in the best interest of Barbadians, Clause 1, sir, in terms of the proposed title, I'm wondering if we can have a debate and a dialogue now in relation to the name of the act, especially in consideration of the points made by Senator Tate, and if we can have a very short caucus to determine the wording that could perhaps provide a resolution, and if that point could be put to the vote, sir, and we conduct the proposal I am considering, sir, is cited as the Temporary Right to Severance Payment Layoff Procedure Settlement Claims Act, and perhaps, sir, that the title reflect the intention which I had raised, sir, in regard to giving effect to the previous act and some reference to the previous act being amended to extend the period for which the previous act has come into play. I intend to make this objection or this suggestion at every clause, sir, that hopefully we can get some form of agreement.
Any clauses the bill has? Senator Boyce, do you have a specific wording of the amendment that you want?
I believe, sir, that if I have a short moment with my colleagues, the proposal is short title 1. It is the title is cited as the temporary rights to severance payment, and there be an inclusion of 1A to give effect to the intention I had spoken about, that this act be, and I haven't finalized it, sir, but
that would have to be in writing.
that would have to be in writing, sir? Yes. How much time do I have, Mr. Perez? I have the, no?
The problem that I am having is whether or not it is a matter now for me to ask the committee if
they're
we
willing
all
to have.
agree that we should take time to allow Senator Boyce to have the caucus, or if we should just get on with the business of the House.
That's fair. That's fair. Do we wish to have time to discuss, or do we just wish to go forward?
Question is, should we go forward the business of the House, or should we pause for the caucus? Honorable members in favor, please say aye. Those against, please say no.
Or pausing. Aye.
Sir, could you repeat just for clarity for the rest of us in the House?
Should we give Mr. Senator Boyce, he is asking for some time to have a caucus to decide on the amendment.
Let's put the question again.
Mr. Chairman,
So, yeah.
I really don't understand. We are in committee. I've asked that I've moved that the clause stand part as read. An honorable member gets up and suggests that they want to make an amendment. We don't have the amendment. The amendment is not ready. And we're being told that some time should be granted. How much time? An hour till tomorrow, 3 days? I don't support it, Mr. Chairman. And I think we need to get on with the government's business.
So the question is that we should get on with the government's business. Put it that way. All honorable members in favor, please say aye.
Mr. Chairman,
Yeah.
I hate to intervene, especially when I have a cupboard who didn't vote against it. But my difficulty is that we force this thing through because the normal procedure for legislation is that you lay it here and it goes, we get some time to study it, you can't get some time to study it, but you did it in 1 day.
No, that's a motion.
And you can't give him 5 minutes. The government is just trying to be a bully. You know, I am not defending Senator. I am saying to you that you got to be fair. You know, you got to be fair. You got to treat people with respect. And you're not doing that. You can get out here and bulldoze everything through the Senate because you have the numbers, you got the power, and somebody got the government business. The government business is a bunch of foolishness. And having a little bit of regard for what the senator had to say is too much. But you forced the bill through us today.
But we did not force the bill.
You forced it, sir.
We amended section 45 to...
You didn't amend it. What you did,
10 days.
what you did was abuse this time. Because you gotta give notice. Nobody give you no notice that they can do that.
We suspended
This-
section 45.2 to allow us to debate it today.
Yes.
We did not.
Under normal, under what the standing orders require, you should have notice. We had a notice of that. So I sit down and I allow you people to just suspend this, suspend that. But the rules provide that you have to give notice of that intention to suspend it. Nobody never get attention here. And then you walk in here and treat people as though they don't matter. He was appointed by the Governor General, like all the rest of us, to have a say in here. And you ignore him because that is not what what is expedient.
I should be ready, Mr. Chairman, by the time we reach the clause 4, so we can proceed, sir. Thank you, Senator Franklin.
Because we
So
can't
do
go
clause
past the
1
thing.
again, do clause 1 again.
Clause 1.
Mr. Chairman, I beg to move that clause 1 stand part.
The question is that clause 1 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Clause 2.
Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part. Honorable senators in favor, please say aye.
Chairman. Was on my feet long before you start hollering aye. Mr. Chairman, procedure for settlement. The minister may by order prescribe the procedure for investigating and settling claims for the purpose of giving effect to the rights of employees to whom Section 6A of the Severance Payments Act, Cap 355A, inserted by the Severance Payment Amendment Act 2020, Act 2020, number 15, applied. It doesn't say applies. You know, so again, sir, we have a situation, where you are doing something in the past. I repeated it earlier, so my proposal, sir, is that this clause be struck out because it is unconstitutional. The minister now would be making laws and backdating law and taking away property from people, and it would offend the Constitution. Yes, because you know the right to property. You know there's certain sections in the Constitution, section 12 to 23. If you want to take away people's property, you have to amend the Constitution. This act does not amend the Constitution. This provision here. So the minister cannot now give an order and backdate it to give effect to what they should have done some time ago. That said, this piece of legislation is totally out of order.
Anyone?
Mr. Chairman, I beg to move that clause 2 stand part.
The question is that clause 2 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it. Pedro? Clause 3, Pedro.
Yeah, there's not copy.
Clause 3.
Clause 3.
Mr. Chairman, I beg to move that clause 3 stand part.
The question is that clause 3 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Yeah.
Clause 4.
You put a question?
I put 3 already.
And
Clause 3. Yeah, I do.
Clause 4.
Mr. Chairman, I beg to move that clause 4 stand par.
Mr. Chairman, pursuant to the standing orders 50, I have submitted in writing an amendment to proposal to clause 4. I propose to read this amendment and put it towards the members of this honorable committee, hopefully to encourage some discourse and a vote that will bring everyone in on the same page. Mr. President, I propose the insertion of a clause. This act shall not come into force until the Severance Payment Amendments Act 2020 be amended to extend the period of commencement and duration of, let's call it effect, to Cap 358 to amend to the end of December 2021. This, I suggest, Mr. President, will take care of the current issue which relates to the effectiveness of the act, where if we hold this act until the previous act is brought forward and amended.
But this is completely different things.
Yeah.
See, this, you can.
Senator Boyce, this amendment does
Clause,
not
in
speak,
addition to clause 4, sir.
this amendment does not speak to clause 4 at all.
Sir, yes, it does. My amendment is that it be inserted to the correction of errors. So it'll be clause 4.4a, a new clause 4.4a, sir.
This is clause 4.
My handwriting is it was a bit rushed, Mr. President.
This this act shall not come into force until the Severance Payment Act 2020 be amended.
So that amendment can, that can go there. That amendment can go there. Because this is a completely different.
Yeah,
law. That can go there.
The amendment bears no relationship whatsoever to clause 4.
I'm sorry, Mr. Chairman.
I said the amendment which I see here, the one submitted, bears no relationship whatsoever to
Isn't the
clause
amendment,
4.
isn't the requirement, sir, that is relevant to the subject matter of the bill, sir? Looking at Standing Order 53A, sir?
It bears no relationship whatsoever to this particular 4.
But, Mr. Chairman, I'm asking you to look at Standing Order 53A, sir. An amendment must be relevant to the subject matter of the bill. The subject matter to the clause which it relates. This clause speaks to correction of errors, sir. You're saying it bears no relevance, sir?
So the amendment will be in relation to the correction of the errors. The amendment can be.
So which error in 4 are you correcting?
I'm starting, sir, not with the error, sir, with the relevance, sir. And the subject matter, sir. That is what I'm starting at. Standing Order 50, Rule 3A, sir.
This particular amendment cannot go with this clause. Definitely not.
What's the basis, sir? Can you refer me to the standing order which you're referring to, sir?
That it has to be relevant to 4. It has to be relevant to 4. There's no relevance whatsoever.
It says, sir, it doesn't say it has to be relevant to 4, sir. Respectfully, 53A says relevant to the subject matter of the bill, sir.
What's his amendment, sir? This is his amendment. And look at that and look at 4.
This will happen further down. This is almost like a new clause.
Yeah.
Commencement. This
Yeah.
section, no, the commencement.
Yeah. If there was a section that dealt with the commencement of the act or anything like that, then this one could
clause 5.
Or yeah, if it was a different new clause you wanted to insert, but it certainly can't go to 4. No, you can't. No,
Respectfully, it expressly says Standing Order 53A, amendment must be relevant to the subject matter. And there is reference to the subject matter of the clause to which it relates, is co-joined.
And to the subject matter of the clause to which it relates.
And we're correcting the errors. There are errors we have just identified, sir, in relation to the whole Severance Payment Amendments Act 2020, and it's relevant to the subject matter of the bill that we're discussing.
You have to apply to have it to be a new section 5, but it definitely cannot be amended on the 4.
If I apply for it to be a new Section 5 at this stage, would it then be considered, sir? Under the section of relevance, sir?
I'll put it to the vote and see what they say, but definitely it can't go.
That is fair, Mr. Chairman. Can it be read again, sir, for the benefits of the members of the House, sir?
He's on it.
I can't. We are at 4 now, so we have to pass 4 and then get the 5.
Clause 4.
Move that clause 4 stand parked.
The question is that clause 4 stand part. Honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
No. Divide.
Divide this clause now. It's 4.
You then have to ask that a new of 5 be included. So we're doing a division on clause 4. Senator Walker?
Aye.
Senator McConney? Aye. Senator Cummings?
Aye.
Senator Dr. Springer?
Aye.
Senator Dr. Holder?
Aye.
Senator Adams?
Aye.
Senator Dr. Haynes?
Aye.
Senator Grant? Aye. Senator Sands?
Aye.
Senator Franklin?
No.
Senator Drake? Senator Wiggins? Senator Reverend Dr. Rogers? Senator Hunt?
Abstain.
Thank you. Senator Nurse? Senator Boyce?
Abstention.
Senator Maynard?
Abstain.
Senator Tate?
Abstain.
What was it? Right. Mr. Chairman, 10 honorable senators voted in favor of the clause. There were 6 abstentions. And 2 noes. Therefore, the clause is passed.
Clause 4 is passed,
Senator Boyce wanted to put clause 5.
but suppose we don't agree with that. Suppose we don't agree with that.
No, you don't agree with it.
Thank you, Mr. President of the committee. Sir, pursuant to Standing Order 50, the proposed amendment is for new clause, which will now be clause 5. It is my submission, Mr. President, that this proposal and the proposed amendment is relevant. Pursuant to Standing Order 50, Rule 6, any proposed new clause shall be considered after the clauses of the bill has been disposed of. At this stage, sir, it is my proposal that the new clause to be considered is what I have provided in writing for the clerk, and which you should have a copy of, sir. The clause reads as follows, sir. New clause 5. This act shall not come into force until the Severance Payment Act 2020 be amended to extend the period. And I just need to just check something quickly.
Commencement, that word is?
Sir, you're quite right. Just a moment, I have it. To extend the period of commencement and duration to the end.
I have
Duration
of
to the end of December 2021, sir. Sir, what is proposed by this, sir, is that
Duration of what?
That's a moment. Of 2021, sir. I just want to see the previous act, sir. The previous act, sir, it says that the amendments made to this act and the principal act should be deemed to have come into operation on the 1st of June 2020 and shall cease to have effect on the 31st of July 2020. So, sir, what I am proposing is that the cease to have an effect, sir, shall move to the 31st day of December 2021. If we make that amendment, sir, and we hold this legislation until that previous act is amended, we will then find that a lot of the issues which have been raised will hopefully dissipate. That is my proposed amendment, sir.
Mr. President, sir, I understand what Senator Boyce is trying to do, but if we start interfering with the date for the act to cease, we have to look at that in the context of how that affects the period within which persons.
Just 1 minute.
Oh.
You can only consider the amendment from the second.
Are you seconding the proposal by Senator?
No, I just wanted to make a submission on what he has submitted, sir.
But it's not a submission yet until it's seconded.
Pardon me, sir?
It is not a submission yet.
Oh,
until
very
it is
well.
seconded.
Very well.
Sir, I second the addition to the bill.
Senator, yes.
Thank you, Mr. Chairman, Mr. Deputy President. Sir, I was just concerned. I understand the intention of Senator Boyce to try to solve the perceived problem, but we have to look at it in the context of if extending the duration would affect the period within which claims can be made, because then it makes that piece of legislation a whole nother ball game. Persons had a specific time within which to make their claims. So to extend it so that we can deal with the bill of 2021, it would still require further amendment to maintain the period within which those persons who are affected by COVID and so on, their claim must still remain within the time frame intended by the 2020 legislation. So it might be, I understand what he's saying, but it seems to me that there would be need for a further clause to protect or to maintain the time frame for claims. If not, you might find people saying, well, if it goes to December and they did not claim in the requisite time, all of a sudden you'll have a whole set of persons coming now to claim, especially if they were outside of the allowed bracket. I'm obliged to you, sir.
Now, this additional clause by Senator Boyce has been seconded, and what I think we should do is to put it to the vote to find out whether or not we agree that this clause should be added. So clause 4 was the last one, this one is clause 5. So you can take a vote. So the question is then, should the new clause 5, as indicated by Senator Boyce, be considered? And we wanted to put it to the vote. Huh? I put the question. All those honorable members in favor of that clause, the additional clause be inserted. I know.
Full clause, actually put a clause.
we go. All right, boys. So all honorable members in favor of the additional clause being inserted, please say aye. Those against, please say no. But it seems as though the noes have it. The noes will have it. No, but anybody call for divide, yeah. Go do the counts, man. Do the count. Do the count, the noes. Hmm? Yeah. The chair is not sure, and the chair is asking for.
The chair has to make.
No, the chair.
Mr. Chairman, the chair has to make a determination, and then if people doubt the chair is saying, then there will be a division. But you have to call it one way or the other.
But I already said the noes have it. Hmm? Yeah, but put it to the thing. I put it already, the noes have it. But
Mr. Chair, I'd like to move that you took no report.
no, you go. Yeah, them for them. Them for them. Oh, I thought I said. Yeah. I said he knows how to. Hmm? No, I said he knows how it twice. I said it twice. Hmm? The question is that report to the, the question is that I do not report is on the speaker, the president, the passing of 1 billion committee. All honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
The chairman has reported to me the passing of 1 billion committee. Senator Walcott.
Mr. President, I beg to move that this bill be now read a third time.
The question is that this bill be read a third time. Those honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. President, I beg to move that this bill do now pass and be cited as the Temporary Right to Severance Payment for Layoff or Short-Time Procedure for Settlement of Claims Act 2021.
The question is that this bill be now passed and so cited. Those honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it. This bill is so passed and so cited.
Mr. President, I beg to move that this sitting be now adjourned, sine die.
The question is that the Senate be now adjourned, sine die. Those honorable senators in favor, please say aye. Those against, please say no. Methinks the ayes have it. This sitting now stands adjourned.